Senate will come to order. Mr. Schaffler, please call the roll.
Senators Amabile, Baisley, Ball, Bridges, Bright, Carson, Catlin,
Excused.
Cutter, Danielson, Doherty,
Excused.
Exum, Frizzell, Gonzalez, Hendrickson, Judah, Kipp, Kirkmeyer, Colker, Lindstedt, Liston, Marchman, Mullica, Pelton B, Pelton R, Rich, Roberts, Rodriguez, Simpson, Snyder, Sullivan, Wallace, Weissman, Zamora Wilson, Senate District 21 vacant. Mr. President.
Let's do this. The morning roll call is 32 present, 0 absent, 2 excused, and 1 vacant. We have a quorum. Senator Baisley, would you please lead us in the Pledge of Allegiance?
Thank you, Mr. President. Members, please join me, and all other folks visiting on the floor and in the gallery, please stand and join me in the Pledge of Allegiance. I pledge allegiance to the flag
Of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Approval of the journal. Senator from Frisco, Roberts.
Thank you so much, Mr. President. I move that the Senate Journal of February 20th, 2026 be approved as corrected by the Secretary.
You've heard the motion. All those in favor say aye. Opposed, no. Wow. That's very compelling. But the ayes have it, and that motion is adopted. Please, Mr. Schaffler, add Senator Catlin to the roll. Senate Services.
Correctly printed, Senate Bill 119, correctly engrossed, Senate Joint Resolution 12, correctly re-revised, House Bill 1150, 1151, 1152, 1153, 1154, 1155, 1156, 1157, 1158, 1159, 1160, 1161, 1162, 1163, 1164, 1165, 1166, and 1167, 1168, 1169, 1170, 1171, 1172, 1173, 1174, 1175, 1176, 1177, 1178, and 1179.
Thank you, Mr. Majority Leader.
Thank you, Madam President. I move the Senate proceed out of order for a moment of personal privilege.
Seeing no objection, the Senate will move out of order for a moment of personal. The motion is to proceed out of order for a moment of personal privilege. All in favor, please say aye.
Aye.
All opposed, no.
No.
Okay, the ayes have it. We will move. Do I have to bang the gavel? Okay. We will proceed out of order for a moment of personal privilege. Senator Coleman.
Thank you very much, Madam President. I request a moment of personal privilege.
Please, granted.
There we go. Members. I know there's a lot going on the floor right now, but I wanted to catch your attention for a brief moment to honor and acknowledge the members of Delta Sigma Theta Sorority Incorporated. The members of the Colorado State Senate acknowledge the Denver alumni chapter of Delta Sigma Theta Sorority Incorporated for their service to the state of Colorado. For 113 years, Delta Sigma Theta Sorority, Inc. has championed sisterhood, scholarship, service, and social action. Founded on January 13, 1913 by 22 visionary women at Howard University, sorority has grown into a global force with over 350,000 members and 1,050 plus chapters chartered. In 1939, the Denver Alumni Chapter has spent 85 years uplifting communities through advocacy, mentorship, and outreach. Guided by its 5-point programmatic thrust, it remains committed to empowering the Black community and beyond. As they honor their legacy, they continue to serve with resilience, carrying forward the torch of generations to come. With love and devotion to your sisterhood, we offer this recognition to the Denver Alumni Chapter, Delta Sigma Theta Sorority Incorporated, at the Colorado State Capitol to commemorate their lasting impact on the state of Colorado. And members, we're joined by the Denver Alumni President, Alice Arline, Nakira Johnson, the Social Action State Coordinator, and Ajay Johnson, Colorado State Facilitator. Please join me in giving all these women in leadership a round of applause.
Senator Marchman.
Thank you, Madam President. Moment of personal privilege, please.
Granted.
Thank you. I just wanted to extend a warm welcome to our Sergeant Jerry's family is visiting us today. We've got Richard and Randy, who were both vets, and then we've got Rex, who's Jerry's dad. Thank you all for being here today, and thank you for your service.
Second reading of bills consent calendar. Senator Roberts.
Thank you, Madam President. I move the Senate resolve itself into the Committee of the Whole for consideration of general order, second reading of bills, consent calendar.
You have heard the motion. All those in favor say aye. Aye. Opposed, no. The motion is adopted, and the Senate will resolve itself into the Committee of the Whole for the consideration of the general order, second reading of bills, consent calendar, and Senator Roberts will take the chair.
Get right into it. The committee will come to order, and the court rule is relaxed. Will the clerk please read the titles of all the bills on the general order's second reading of bills consent calendar?
Senate Bill 85 by Senators Frizzell and Ball and Representatives Duran and Hartsook concerning military protection orders and in connection therewith a peace officer's duty to determine whether a military protection order exists when responding to an incident of domestic violence and a requirement for the court to consider the existence of a military protection order as relevant evidence when determining whether to issue a temporary civil protection order. Senate Bill 25 by Senators Rich and Snyder and Representative Marshall concerning land survey monumentation.
Mr. Majority Leader.
Thank you, Mr. Chair. I move for the passage of all the bills on general order, second reading of bills consent calendar, which includes Senate Bill 85 in the Judiciary Report and Senate Bill 25 in the Transportation Energy Report.
Is there any discussion on the committee reports? Seeing none, the motion before us is the adoption of all the reports to the bills on the general order, second reading of bills consent calendar. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the reports are adopted. Is there any discussion of any of the bills on the consent calendar? Seeing none, the motion before the body is the adoption of all the bills on the general order, second reading of bills consent calendar. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and the bills are adopted. Majority Leader Rodriguez.
Thank you, Mr. Chair. I move the committee rise and report.
The motion is for the committee to rise and report. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and the committee will rise and report.
Senate will come to order. Senator Roberts.
Thank you, Mr. President. The committee had a number of bills under consideration. Will the clerk please read the report?
February 23rd, 2026. Mr. President, your committee of the whole begs leave to report has had under consideration the following attached bills, being the second reading thereof, and makes following recommendations thereon. Senate Bill 85 as amended, Senate Bill 25 as amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage.
Senator Roberts.
Thank you, Mr. President. I move the adoption of the report.
The motion is adopted in the committee of the whole report. Are there any no votes? With a vote of 33 ayes, 0 noes, 0 absent, 1 excused, 1 vacant, the committee of the whole report is adopted. Senate Bill 85 is amended, 25 is amended, passed, second reading, order and goes placed on the calendar for third reading and final passage. General orders, second reading of the bill, Senator Roberts.
Thank you, Mr. President. I move the Senate resolve itself into the Committee of the Whole for the consideration of general orders, second reading of bills.
You've heard the motion. All those in favor say aye. Opposed, no. The ayes have it. The motion is adopted. The Senate will resolve itself in Committee of the Whole for consideration of general orders, second reading of the bills, and Senator Roberts will take the chair. Ready?
The committee will come to order, and the court rule is relaxed for everyone in the chamber. Majority Leader, Majority Leader Rodriguez.
Thank you, Mr. Chair. I move to lay over Senate Bill 37 until Wednesday, February 25th, 2025.
The motion is to lay over Senate Bill 37 until Wednesday, February 25th. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and that bill will lay over. Majority Leader Rodriguez.
Thank you, Mr. Chair. I move the Senate proceed out of order to take up Senate Bill 5.
The motion is to proceed out of order to take up Senate Bill 5. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and that motion is adopted. Will the clerk please read the title to Senate Bill 5?
Senate Bill 5 by Senators Weissman and Gonzalez and Representative Mabry and Zakai concerning state court remedies for violations of federal constitutional rights occurring during immigration enforcement.
Senator Weissman.
Thank you, Mr. Chair. We move SB 5 and the committee reports from Judiciary and Appropriations.
To the Appropriations Committee report.
The Appropriations report involves some cash fund. We ask for your support.
Is there any further discussion on the Appropriations Committee report? Seeing none, the motion before us is the adoption of the Appropriations Committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and that committee report is adopted. To the Judiciary report, Senator Weissman.
Thank you. In Judiciary, we adopted one amendment that does a collection of things. Some of them are small and technical. Some involve conforming the action in SB 5 better to existing 1983 doctrine. We ask for your support.
Is there any further discussion on the Judiciary Committee report? Are you okay? Okay, sorry. Seeing none, the motion before us is the adoption of the Judiciary Committee report. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and that committee report is adopted. To the bill, Senator Weissman.
Thank you, Mr. Chair. A little bit more cleanup, so we have an amendment.
There is an amendment at the desk. Will the clerk please read L008?
Amendment L008, amend the
Senator
Judiciary
Weissman.
Committee.
Thank you, Mr. Chair. We move L8 to Senate Bill 5.
To the amendment.
Members, L8 just adds a bit more language to incorporate the notion of proximate cause in this action that is to track Section 1983 jurisprudence, which is something of a cousin to what we're doing here. Also, nonpartisan staff found a missing comma, so we're putting a comma back in. No substantive change is intended by that. We ask for your support of L8.
Is there any further discussion on the amendment? Seeing none, the motion before us is the adoption of L008. All those in favor say aye.
Aye.
Those opposed, no. The ayes have it, and that amendment is adopted. Senator Gonzalez.
Thank you, Mr. Chair. Colleagues, how bad is it going to have to get? How bad are the actions of federal immigration enforcement going to have to get before we all 100%, 35-0 can get to the point to where we acknowledge and appreciate that the Constitution does in fact protect us all? Now, they have been violating and trampling on the rights of immigrants for years. Now, in this year, we have witnessed the extent to which the rights of U.S. citizens are being trampled upon. Not just trampled upon, the rights of U.S. citizens are being so infringed upon that they are killing U.S. citizens in broad daylight and then telling us to not believe what we can see with our own eyes. Y'all, how bad is it gonna have to get? U.S. citizen Alex Preddy, utilizing his First and Second Amendment rights. His constitutional rights were trampled upon. How bad is it going to have to get? That is why we bring forward Senate Bill 5 for your consideration today. I hope that this bill comes out of this chamber 35-0. Because how bad is it going to have to get before Coloradans' civil rights, Coloradans' constitutional rights are trampled and infringed upon over the course and conduct of federal immigration enforcement, before we stand up and say, you know what? The Constitution does, in fact, protect us all. I ask for an aye vote on this bill. And let's go forward and see what our colleagues have to say.
Further discussion? We're on the bill. Senator Baisley.
Thank you, Mr. Chairman. You know, something I really appreciate about the bill is that it does address the notion that the Constitution protects us all. Because it says a person who is injured during civil immigration enforcement by another person will go both ways. It does not say that this only protects the agitator who is involving him or herself in a lawful action by a federal government agent. So therefore, if the agitator injures one of the law enforcement agents, then that agitator can be charged civilly, that action brought up by the employee of the United States federal government who is enacting that legal action. So it does go both ways, and for that I appreciate. So we just need to make certain that that our friends in the federal government, when they come to Colorado, understand that if any of those who have visited here for a legal law enforcement action, if they are injured by someone who is trying to interfere with their duties, then they could be liable for injunctive relief. So I appreciate that. But I do think that there's an area for clarification that's necessary. And towards that, I would like to introduce this, Mr. Chairman.
There is an amendment at the desk. Will the clerk please read L004?
Amendment L004, amend the Judiciary Committee
Senator
report
Baisley.
date.
Thank you, Mr. Chairman. I move L004 to Senate Bill 005.
To the amendment.
Thank you, Mr. Chairman. So this is will strengthen the action, the conscious action, so that there is no room for just judgment that the person who did the violation did so without understanding the laws, because we're changing the laws right now, on the fly. People coming to our state from another state as a federal employee to enforce a law federally or a constitutional requirement may not know about the fluidity of our laws. So what this will do is change from just violated to knowingly and intentionally violated, so that it is clear that someone did not just accidentally stumble upon a law that we've recently passed that's not even on the printed books yet, and it could trip them up, and it would be really an unfair action. So this would clarify that. So I ask you members to vote yes on L004, and let's make sure that it is clear and fair for everyone. Thank you, Mr. Chairman.
Senator Weissman.
Thanks, Mr. Chair. Members, bottom line up front, I'm going to ask for a no vote on L4. I'll say a little bit about why. First of all, to clarify just how the cause of action here works, federal officials or others, because as noted, we are talking about any person language here, actually don't have to worry about the state of state law, because what we're talking about here involves violation of rights guaranteed by the federal Constitution, the United States Constitution, and only that, not the Colorado Constitution, not state statutory law. So it is true that we are in the business of updating and upgrading our laws here to better protect the rights of people in our state from various abuses. However, that is not within the four corners of the action. So even if statutory law in Colorado does change, it's not going to bear on how the action goes. An individual who might be concerned about their liability under this action only needs to have some understanding of what rights are protected by the U.S. Constitution. Used to be that federal officials were trained on that. It doesn't seem to be happening as much anymore. We did just adopt L8, introducing the notion of proximate cause to this action. There should be spare copies up at the desk if members want to take a look at that. The notion of proximate cause comes from a Section 1983 action. Goes back at least decades, so to us it made sense to incorporate that here. What we don't find in the civil rights context is this kind of mental state requirement. This is a higher bar to climb over for an injured person who has had their constitutional rights violated. We don't see analog to this in the 1983 context. We don't want to make it harder for people whose rights are violated to obtain redress. So for all those reasons, asking for a no vote on L4.
Further discussion of this amendment? Senator Carson.
Thank you, Mr. Chairman. I'd like to support this amendment by the senator from Woodland Park. I think it adds an important element in balancing the legal disputes that could occur under this piece of legislation. Certainly, on the surface, this bill sounds very reasonable. If someone's constitutional rights are violated, we want to have protection for those individuals. But here's the problem. How is all of that going to be determined? You know, a few weeks ago, it was reported that all of these cases are finally working their way through the system here in the city of Denver. 4 or 5 years ago now, when we had quite a wide range of protests and quite a few individuals who shut down businesses, destroyed property, ransacked this building, spray painted all over this building. It took, I think, 9 months or so to get this building repaired. And then I heard on the news that so far, the wonderful taxpayers of the city of Denver have had to pay $23 million in damages to the folks who participated in those, whatever you want to call them. And apparently, when everything shakes out, the taxpayers of Denver are going to get to pay $40 million out of their pockets as a result of these disputes and these protests. And so just speaking as an attorney, you know, the way these sorts of disputes get sorted out, they don't actually go to trial and have a judge and a jury and so forth decide whether someone's constitutional rights were violated. What happens is you have a whole, and by the way, this type of litigation, this legislation is a dream for trial lawyers, because right here in the bill you have a provision that says in an action pursuant, an action that's brought pursuant to this legislation, the court shall award reasonable attorney fees and costs to the prevailing plaintiff. So you're going to have a whole bunch of attorneys lining up to take these cases, and they don't actually go to trial. What happens is you just have hundreds and hundreds of these type of disputes, and anybody who was there at a particular day at a particular protest or an event, they'll line up and file a dispute that their rights were somehow violated. And at the end of the day, it's going to be the taxpayers of, in this case, it'd be the federal taxpayers. In the case of the disputes that went on here in Denver a number of years ago, it was the taxpayers of Denver which, you know, if I lived in Denver, I certainly wouldn't be too thrilled about the having to foot that bill with all the other priorities folks have for the upkeep of the operations of the city of Denver, and then to have to pay out these type of settlement costs. And so I envision the same sort of thing happening here. While it sounds good, someone's constitutional rights are violated, but the good senator from Woodland Park has brought in, I think, a very reasonable amendment to simply say, if they were knowingly and intentionally violated, then we have, I think, potentially a legitimate complaint that an individual's rights were violated, and they should then be entitled to some damages, some remedies, and the attorneys as well for taking that case. But just leaving this wide open to open the floodgates on various legal settlements, again, we're just going to fuel this endless process of litigation and settlements. And, you know, I suspect in the vast majority of cases, people's rights have not actually been violated. They just felt that there was a pot of money made available to them, and so why not line up and see if you can get your share of the settlement funds. And I think in the case of Denver, I heard on the news report, I have heard several instances which I would regard as very legitimate complaints and claims of individuals who were injured. However, again, it doesn't end with those 2 or 3 individuals who are injured. It results in hundreds and hundreds of legal settlement claims, and ultimately, it's the taxpayers that pay the bill. And so I support the amendment here. I think it's a reasonable compromise. It puts some guardrails around this type of language and make sure that we have actual legitimate complaints that are being disputed and litigated and so forth in the legal system. So with that, I thank the chair.
Further discussion on L004? Seeing none, Senator Gonzalez.
Well, I appreciate the cost concerns, and you know the best way to not have to incur costs is not to violate people's constitutional rights in the first place. And so that's the actual way to address this concern. Again, I ask for a no vote on the amendment.
Further discussion on the amendment? Seeing none, the motion before us is the adoption of L004. All those in favor say aye. Aye. Those opposed, no. No. The noes have it, and that amendment is lost. Further discussion on the bill, Senator Liston.
Thank you, Mr. Chairman. Well, members, we've all seen the unfortunate actions that occurred up in Minneapolis. But as Paul Harvey would say, let's hear the rest of the story. Those of us who remember Paul Harvey, you know, he was a well-known radio broadcaster, and he would bring out the other side of the story. And what the good senator from Denver has not brought out, what precipitated and caused much of the uproar that went on in Minneapolis. First of all, you had a governor of the state of Minnesota and the mayor of Minneapolis who were preaching open opposition to ICE and open insurrection to thwart the actions of our law enforcement officers. Remember that. There are numerous quotes where the governor of Minnesota and the mayor of Minneapolis, in so many words, told ICE to get the heck out of there. They were only there doing their job of enforcing immigration law that was passed dutifully by the Congress of the United States. And these laws have been on the books for years, dating back for 5, 10, 20, 30 years or more. We have our borders to protect, and the actions of ICE were there to enforce the law. What the senator from Denver also didn't say, she was impugning the integrity of the law enforcement officers that were doing their job. The unfortunate citizen who took her car and rammed it into one of the ICE officers, who had just a few weeks before had been run into by another car and dragged some 150 to 200 feet. She weaponized her car and ran into this ICE officers after she was repeatedly told to stop and get out of the car. She ignored the lawful orders and weaponized her car and drove it into the ICE officer, and unfortunately, she suffered the consequences. If it had been most any other ICE officer or law enforcement officer, they would have done the same thing. They are allowed to protect themselves. Secondly, a few days later, the gentleman who brought a loaded 9mm handgun to the riots that were trying to thwart the lawful actions of ICE. Not only did he bring he brought 2 clips, 2 magazines. What kind of a person brings a loaded 9mm pistol to an open insurrection where bottles of frozen water are being thrown at ICE officers, and he was screaming and yelling in their faces, and he was actively pushing ICE officers, trying to thwart their lawful actions. Unfortunately, he too suffered the grave consequences of bringing a loaded firearm to a very contentious situation. And then you contrast that with the ICE actions in states like Texas, Florida, Arizona, New Jersey, Georgia, and most other states where the law enforcement officers and the mayors and the governors of those states allowed ICE to perform their duties. There were no severe actions at all and repercussions that happened in Minneapolis. It's very unfortunate that people are allowed to protest. Peaceful protest is allowed. It's encouraged in this country. But when you start pushing and shoving and doing the things that were done in Minneapolis, it's in a very contentious situation. You're going to have things that spin out of control. And with that in mind, Mr. Chairman, I do have an amendment.
There's an amendment at the desk. Will the clerk please read L005?
Amendment L005, amend the Judiciary Committee report dated February 2nd, 2026, page 1, line 19,
Senator
strike.
Liston.
Thank you, Mr. Chair. Mr. Chair, I move Amendment L005 to Senate Bill 5.
To the amendment.
Very good. Members, what L005 does, it adds a provision that a cause of action may be brought only if the plaintiff did not provoke the conduct giving them rise to the claim. This amendment assures that an individual is protected from a cause of action if they are defending or protecting themselves in response to the plaintiff's action. This amendment addresses the current climate surrounding immigration practices in which protests and citizen involvement can turn very violent and threats can be exchanged. So in reasonable terms or logical terms, if for instance, if I'm there and someone pushes me and they're screaming and yelling, and they push me, and I push them back, which can happen, and they should fall over. I am just protecting my rights. So a cause of action cannot be brought against me because I am there protecting myself. If somebody pushes me and I push them back, and then they turn around and want to try and sue me. This is only reasonable and fair, and I urge an aye vote on Amendment L005. Thank you, Mr. Chairman.
Senator Weissman.
Thanks, Mr. Chair. Members, for the sake of protecting the rights under the Constitution that we all swore an oath to when we came in here, for the sake of fidelity to, frankly, everything this country is about as we come up on our 250th year, for the sake of not trafficking in the kind of victim blaming that regimes like Russia and China and Hungary traffic in, I'm going to ask for a no vote on L5. To some of the comments we've heard so far, I was serving in the House in 2020 when there were protests, when there was tear gas. I remember walking in this place and the stench of the pepper spray was not cleared out of the air yet. I do not condone when people use violence and break the law. I do stand by the right of anybody, regardless of their ideology, to engage in lawful First Amendment speech and protest and petition for redress. And the thing about this country, the thing that has made us unique and that is in the balance right now is that two things can be true at the same time. And we need to be really careful to not paint protest and political disobedience with the brush of unlawfulness, because that's happening up here in this well, I think. If, in the course of exercising their rights, somebody violates the law, they should be held answerable for that. But the way that this country works is that you are answerable in proportion. If you take a swing at a cop, you can answer for that. What we don't have in this country is carte blanche for law enforcement to use unlimited force. Contra some of the rhetoric emanating from the highest levels of federal government in this country, there is no absolute immunity for that kind of thing. Going and engaging in protest, using your First Amendment rights, does not legally open you up to being thrown to the ground, to being clubbed, to being shot, to being killed. That is not this country. That is other countries in the world right now that we should be thankful we don't live in, but that is not this country. Except that the person is not liable if the person provoked the conduct. If I'm a judge, if I could make sense of this at all, which is going to be hard to do, at the very least, it guts the bill, which is unfortunate, because this is our fundamental document. It is supposed to transcend party. It is supposed to transcend who's in power right now. A national conservative gun rights group spoke up after Mr. Preddy was killed in Minnesota. He was a lawful holder of a permit to carry, and what he was doing that day was in compliance with the law. And then he was disarmed and shot 10 times in the back. I don't know if there's ever going to be remedy for that because of active interference in the investigation, but that is the kind of conduct that measures like this are intended to provide redress for, and it is why we need to not cloud the water with language like this. So I ask for a no vote on L5.
Further discussion on the amendment. Senator Zamora Wilson.
Thank you, Mr. Chair. I rise in support of L005. What this does is it puts up guardrails against frivolous lawsuits. in these contentious moments where there's incredible division and it's politically charged, emotions rising high, there is the fog of war, as we say in the military, where people could just bump into someone, which could be turned into a lawsuit, which will increase demand of lawsuits, which will increase, we'll have to supply it, which increases costs to the taxpayer and our judicial system. Additionally, if we don't have these guardrails, this is going to create a chilling effect on the enforcement, as agents could face costly lawsuits for alleged constitutional violations during routine duties. If such individuals are considered protected by the Constitution, then there doesn't need to be any remedy, this bill. If protecting constitutional rights is the goal here, then I would highly suggest that we put reforms at the federal level, not at the state level. I urge a yes vote on L005. Thank you.
Senator Liston.
Thank you, Mr. Chair. Well, members, I just want to clarify, first of all, the intent of L005, with all due respect to the good senator from Aurora, the intent of my amendment is not to gut the bill. It's just to protect the person who happens to be at the demonstration. Once again, we all support peaceful opposition and demonstration. That's our right under the Constitution. I agree with that. But when you have a very volatile situation, which has occurred in Minneapolis, and you have the governor of the state and the mayor encouraging people to come out and forcefully and angrily thwart the lawful duties of law enforcement, that is going to turn a peaceful protest into a hyperbolic protest. And to my point, a lot of the protesters, and there's video out there, these were not normal, these were not just regular protesters carrying a sign. They had helmets, they had body armor on, they had masks. They could not be identified themselves either. Now, when you're coming equipped to a protest with your own body armor and helmets and a mask on, and you're screaming and yelling at a law enforcement officer, whether it's ICE or the police or whomever it may be, what do you expect? Some pushing and shoving may go on. There may be people there supporting law enforcement, as there were, and one event leads to another, so all of a sudden the person who is there in support of law enforcement, they're being drug into court and having to pay court costs, hire an attorney, potentially going to jail, whatever. Also, what is not being said, which is true, I'm not saying this is true of all of the protesters that are against ICE, but they are paid agitators. They are being funded by outside groups. They're being bussed in and brought in from outside the city to thwart law enforcement. And they go from one locale to another. Those are not your normal protesters. These are paid agitators that have people and organizations behind them with money that say, well, if you get arrested, we'll bail you out just like that because we have the resources. Your job is to go in there and thwart law enforcement to the best of your ability. And if there's pushing and shoving, we'll bail you out. Now, if it happens to the ordinary citizen who might be there in support, one way or the other, they're on their own. So all we're trying to do here is, once again, I'll read what it says. It says, relief, except that the person is not liable to the person who have their rights violated if the person who have their rights violated provoke the conduct that caused the violation. So what's good for the goose is good for the gander. Members, I urge an aye vote on Amendment L005. Thank you, Mr. Chairman.
Senator Carson.
Thank you, Mr. Chairman. I rise to support the amendment by the senator from Colorado Springs, Amendment 5 here. And similar to Amendment 4, which was defeated, I think this basically just sets some balance into the equation so that we can get at what would be actual legitimate violations of someone's constitutional rights. The senator from Denver made the comment that the best way to not have to pay out a whole bunch of legal settlements is to not violate anybody's rights in the first place. Well, that's what we're trying to get at here. That's why we're offering these amendments, that if we can have valid violations litigated and reviewed in the legal process, then we would say the bill could pay out damages. But what we want to avoid is these frivolous claims, these endless claims, which the taxpayers end up having to pay out. Now, the senator from Aurora, I can't disagree with most of what he said about peaceful protests or legitimate protests. I wasn't here in the actual building at the time of those protests from 4 or 5 years ago, but I don't think anybody is saying that you don't have the right to peaceful protests, but these were not peaceful protests. These were situations where the law enforcement officials of this city had to use some mechanism, in many cases it was tear gas, to stop the endless rioting and ransacking of businesses and buildings, and actually harming individuals. If these type of protests get out of hand, you end up with people being very seriously injured and even killed in the general public. So law enforcement has to do their job. We expect that of them, and I think what we've learned from the situation in Minneapolis and the tragedies that occurred there is that both sides, if you want to look at it that way, need to take a step back and allow cooler heads to prevail. And I think that's kind of the situation that has evolved in Minneapolis and in Minnesota. Certainly, I would expect if you had a federal law enforcement official deliberately violating the rights of an individual's right to free speech, to peaceably assemble, if that person was attacked without any reason at all, I would expect that law enforcement official to be relieved, to be disciplined at a minimum, and probably terminated. There is an administrative process for these type of things, and I think the law enforcement community in general takes those type of violations very seriously. And if you look at the reaction of Department of Homeland Security to what has occurred in Minneapolis, and again, these were tragedies, I think they have taken another look at some of their activities as well. But the implication of this bill is really that law enforcement is seeking to deprive people of their constitutional rights to peaceably assemble, to have free speech, to have freedom of the press, to engage in legitimate protests. And I'm not seeing that occurring out there. What I'm seeing is violent confrontations that are occurring, and I don't know what we expect. Do we expect the law enforcement officials to just ignore it, walk away? I think the result of that would be a catastrophe for the local communities. I mean, think if you're a business person in a downtown area, in a community where these type of protests are occurring, and the law enforcement community just decides, well, we really can't do anything here. The folks are just peaceably assembling, when in fact what's happening is violent confrontation, breaking into businesses, breaking windows, as occurred here in Denver. I don't think anyone could dispute what occurred here 5 years ago in the city of Denver. The whole city was basically shut down. And so law enforcement had to respond to that in some way and get the situation under control. Right here in this building, even, it got to that point. So again, I think the senator from Colorado Springs has offered an amendment which helps us get at what would be valid, legitimate disputes under the legislation. And so I think it's a good compromise and allows us to make sure that we're not going to, once again, end up with endless legal settlements with the taxpayers footing the bill, which seems to be what typically happens in these kind of situations where legislations and local government meetings are held and these type of things. And the resolution is always, it's simple for the folks in government to say, well, we'll just pay out settlement checks because it's not coming out of their pocket. It's not going to come out of anybody's pocket around here. But ultimately, the taxpayers get to pay the bill. And so that's why I object to the legislation and support this amendment. I think it improves the bill.
Further discussion on the amendment? Senator Gonzalez.
Now, I'm not about to go and get down into the debate of whether or not there are, quote unquote, very fine people on both sides of this debate. There's been a lot of discussion from this side of the aisle about protests that took place in Denver. I don't seem to recall as much pearl clutching when Charlottesville took place. I don't seem to recall as much of this pearl clutching when Kyle Rittenhouse showed up in Kenosha in 2020. I don't seem to recall this level of, but whatever will we do? In the aftermath of January 6th from this side of the aisle, where were the questions and concerns around costs then? Regardless, I will say, and I will just remind my colleagues, that the title of this bill is not about broad protest. It is about violations of our constitutional rights that occur during civil immigration enforcement. That is a narrowing context. And so I will say that Denver, Charlottesville, Kyle Rittenhouse, January 6th all fall outside this title. And so in the context of this amendment that we are currently debating, I will ask for a no vote, and I'll ask for an aye vote on the original bill.
Further discussion on the amendment L005. Senator Kirkmeyer.
Thank you, Mr. Chair. Members, I rise in support of amendment number 5. And here's the thing. Here's how we started off. Here's how we started off this bill. How bad does it have to get? How bad does it have to get before law enforcement officers say enough's enough and no longer am I going to come be a law enforcement officer in this state, anywhere in this state? Just how bad does it have to get? Let me remind you, there are sections in this bill that say things like this. To the maximum extent permissible under the United States Constitution, a grant of immunity to a defendant who would be a person. Under this bill, it says a person. It doesn't specifically call out law enforcement, but I think we all know where it's going. But a person, if a person who is injured during a civil immigration enforcement by another person, whether or not under the color of law, violates the United States Constitution while participating in a civil immigration enforcement matter. But here's what I heard at the beginning of this. How bad does it have to get? Trampling on the rights of U.S. citizens. You know, there's the Fifth Amendment and the 14th Amendment that have due process in it. Due process. That's for everyone. U.S. citizens, non-U.S. citizens, due process. And for a legislator to stand here at the microphone and talk about trampling everyone's constitutional rights while declaring tried and guilty people in another state, which is why we have to have this bill in this state, is appalling. Due process. In this country, you're innocent until proven guilty. That's what due process is about. That is the basis, the foundation for Amendment 5 and Amendment 14. Due process. You're innocent until proven guilty. So, in this bill, page 5, to the maximum extent permissible under the United States Constitution, a grant of immunity to a defendant, including but not limited to, so to a defendant, which is a person, but I think we all know that we're going after law enforcement here again. Maybe even first responders, any person, but think about who gets immunity. Sovereign immunity, official immunity, intergovernmental immunity, qualified immunity. Colorado Governmental Immunity Act does not apply in an action brought pursuant to this section. Our first responders, our law enforcement agencies, our state patrol, our public works folks, people that work at CDOT, our health department folks. No governmental immunity. I'm just going to remind you all. In 2019, a bill was passed, 217, took away governmental immunity.
Senator Kirkmeyer,
I'm getting there.
This does not relate to L005.
Okay. Anyways, thank you, Mr. Chair. Just going to remind you, and the reason we are asking for Amendment 5 is just remind you. In 2019, we passed bills, took away governmental immunity. For the last few years, we've been passing bills that make it unlawful for a peace officer or people, not just a peace officer, to work with ICE, to work with the federal immigration. And we ended up being the second most dangerous state in the nation. We're just asking for a simple amendment here to clear this up, to ensure that we don't run the risk of what happened after what we did in 2019, that we don't lose law enforcement officials, that we have people whose rights are not trampled on both sides of this. I think the comment was, very fine people on both sides, and we're not going to get into the weeds. Well, very fine people on both sides should not have their rights violated, and they should be protected. I ask for an aye vote.
Senator Weissman.
Thank you, Mr. Chair. As enough dust in the air up here, I wanted to come and clear some of it up. Yes, it's a correct statement that page 5 does say to the maximum extent permissible under the U.S. Constitution, certain immunities don't apply. What that means is they actually do apply, because if you dig into the doctrine of Bivens, if you dig into 1983, and we clarified that last point in a committee amendment, if folks took a look at the committee report, if you are a defendant in one of these actions, yeah, there's immunity, not absolute immunity, to be really clear. There is immunity of the sort pursuant to federal law that has evolved over decades. I'm happy to clear up any questions if any folks ever want to come and talk to me before the posture of second reading. We don't disavow that because we can't, because that's federal law. What we can do, and if you looked at the ledge deck, what state law has done for over 200 years, and in fact what English common law did in the middle of the 1700s before we were a country, is simply provide a forum to even get into the question. We are doing this bill. We are bringing SB 5. I am asking for a no on L5 because a person whose constitutional rights are violated, who is at the wrong end of an impermissible search, who is at the wrong end of excessive force, who is at the wrong end of violation of due process under the Fifth Amendment. 14th doesn't apply here because we're talking federal constitution. That's 5. 14 governs the states. Who is at the wrong end of a violation of their First Amendment, maybe their Second Amendment. If I'm a lawful, permitted firearms carrying individual in a state where that's allowed, and I'm shot 10 times in the back, is there a colorable Second Amendment violation too on top of everything else? Maybe. Somebody might want to at least have their day in court about that. The point is just to get into the courthouse door. And yes, the federal defendant will be able to assert some immunities. That's how the law goes. We say nothing more or less than that. As to due process, this is a civil action. That means, like any other civil action, plaintiff, in this case the injured person, or their legal successor in interest if they're dead from impermissible use of force, plaintiff has the burden by a preponderance. Federal defendants get to assert all manner of immunities. They might even be able to remove to federal court. Federal law lets them do that. We don't seek to change that. So defendants have ample due process. The problem here is that because there is no clear federal statutory remedy, because a Bivens action is insufficient, the problem is that people who were beaten or have their homes broken into or their cars broken into, who are shot dead, they don't have any due process. The point of SB 5 is that due process, because that's what this country is supposed to be about. So to keep SB 5 intact and functional, and to afford robust due process for all of our constituents, any county, any party, for vindication of constitutional rights, I ask for a no vote on L5.
Senator Liston.
Thank you, Mr. Chairman. Members, I do renew my motion for the passage of Amendment L005, but I did want to set the record straight. The good senator from Denver was referencing what happened on January the 6th, 2001. I would remind the senators that none of the people who were there on January the 6th were carrying firearms, and the only person who was shot dead was shot by a federal officer. She was unarmed, and she was not carrying any type of firearm. She was shot in the face. As to Kyle Rittenhour, he was there correctly or incorrectly carrying a firearm, but he was there to protect himself, not from the government, but from other rioters, because he thought that his life was in danger, and he was ultimately acquitted. And also, as it relates to 2020 here, many of us were at the Capitol. I distinctly remember how the Capitol was trashed and vilified. Windows were shot out, literally were shot out. The Senate Majority Leader, I believe, had his car set on fire, and tens of thousands of really millions of dollars of damage were done to the Capitol, and which is part of the reason why we see all of those steel pillars that go all the way around the Capitol. So, and all of the rioters and the damage, those it was not done by supporters of law enforcement. It was done by people who were against law enforcement. They were there to, quite frankly, if they had the opportunity, they would have burned down the Capitol if they could have gotten in.
Okay.
But all of the
Okay,
damage that was done
Senator Liston.
You know my
A lot
point.
of
Thank you. Thank you.
speculation and inaccurate statements are being
Thank you,
made.
Mr. Chairman.
Let's move on. We are on L005. Senator Carson.
Just to make a couple of wrap-up comments here on Amendment 5. I think one comment I make about this bill, and the senator from Aurora, I think alluded to a lot of the federal issues and federal litigation and issues that have gone all the way up to the U.S. Supreme Court on what type of immunity law enforcement officials have or do not have. And the U.S. Supreme Court has basically said they have a great deal of immunity, and so I think that's sort of the motivation between bringing this bill. I suspect that it will be tied up, if it passes, here in the Senate and in the House. I suspect it'll be tied up in quite a bit of litigation, but I think it is important, if we just read the language of the bill, I just think it's overly vague and would make it very difficult for law enforcement to do their job, and that's why I think this amendment, both Amendment 5 and the one that preceded it 4, I think strikes a good balance. But the way the language reads is a person found to have violated the United States Constitution while participating in civil immigration enforcement is liable to the person whose rights are violated for legal or equitable relief or any other appropriate relief. I mean, put yourself in the shoes of a law enforcement official. Basically, this language is so broad and vague that you're going to have law enforcement officials, when they're directed to maintain law and order, to keep the peace, standing there thinking, well, if I push back at the violence that's beginning to occur here, I'm going to be subject to all sorts of legal disputes. I'm going to be named in court filings, in legal disputes, and I might ultimately have to pay funds, which, as I said, I think would in reality be paid by the taxpayers. But if you're a law enforcement official, you're not going to want to have to face that possibility. You're asked to do your job, and so I think continually passing these type of bills is going to subject our law enforcement folks to a dangerous and difficult situation, and then we're going to come back and complain when law and order isn't maintained, when the peace isn't preserved, and when people's constitutional rights aren't protected. Because remember, it's the law enforcement officials' job too to maintain order so that people do have their rights to peaceably assemble and to speak freely and to protest. They are participants in preserving and protecting folks' constitutional rights as well. So with that, I would urge an aye vote for Amendment 005.
See no further discussion. The motion before us is the adoption of L005. All those in favor say aye. Aye. Those opposed, no. No! The noes have it, and that amendment is lost. To the bill, Senator Pelton.
Thank you, Mr. Chair. So I want to go back to where at the very beginning is how bad is it going to get before we do something? How bad? I'm going to read an op-ed from the Denver Post. In the early morning of June 1st, U.S. Immigration and Customs Enforcement and local and county law enforcement officials entered the homes of workers from the Wildcat Dairy in Fort Morgan. While terrified and spouses looked on, ICE arrested 11 dairy workers whose primary job is to milk, feed, and clean up after the dairy cows. These workers were not charged with civil immigration violations, but instead are facing felony charges of criminal impersonation and forging of documents. This raid is deeply alarming to the immigration community and to its allies in Colorado. First, the raid is a direct contradiction of the Obama administration. Stated enforcement goals. In 2009, testimony to the Senate Judiciary Committee, Homeland Security Secretary Janet Napolitano stated that ICE will focus its resources within the worksite enforcement program on the criminal prosecution of employers who knowingly hire illegal workers in order to target the root cause of the illegal immigration. My question for the sponsors are, how bad did it have to get in 2011 when this happened? Or does it only matter when it happens in Denver and Aurora? How bad does it have to get to be able to put food on the tables of the folks? This is what happens when we worry about who the President of the United States is and not what laws that we should be focusing on here in Colorado. This was detrimental to my communities out there. None of us liked what was going on, but we understood it was the law. And people were breaking the law. And if you break the law, you must be punished for breaking the law. And we understood that. There was no protests. We weren't out there, and we didn't make 9 News, we didn't do any of that stuff. We understood what the law meant. The frustration that I have with what's going on right here is we should be focusing on what's going on in Colorado and not at the federal level. And we should not be worried about who the president is at that time. Because this happened during the Obama administration. The Obama administration that deported the most illegal immigration that was going on in the United States. I find a lot of frustration with my communities when it comes down to this stuff. I appreciate where the senators are coming from on their communities, but I also want to point out the hypocrisy of when it matters which president's in the White House. So I ask for a no vote on Senate Bill 5.
Senator Gonzalez.
Thank you to the senator from Sterling for reminding us about what took place at the Wildcat raid back in 2011. At that time, I was a paralegal at an immigration law firm. I actually sat in a room full of 30 children whose dads had gotten illegally detained during said enforcement action. Local sheriff illegally collaborated with the Department of Homeland Security in order to enact that raid. Look it up, those criminal charges were all dropped. There was actually a protest that took place. Father's Day, actually. Just a few days after that raid took place, led by a 6-year-old who walked down the streets of Fort Morgan to the Fort Morgan County Courthouse. I was there. I was protesting Obama then too. It's a weird thing when you're seeing this side of the aisle stand up to say, "Don't tread on me." You would think that conservatives would champion a bill that protects Coloradans from federal overreach, but here we are. Ask for an aye vote on the bill.
Senator Rich.
Thank you, Mr. Chair. I was listening to a lot of this that was going on, and of course, I believe there's a lot of reactionary because of other things that have happened in other states. And I do appreciate the comments from the good senator from Brighton, also the good senator from Sterling, because this bill, instead of being reactionary about what took place in Minneapolis or in any of the other states, it would be good if we would keep it to the state of Colorado. One of the things that the good senator from Denver said, a lot of things were said, but one of the things that I wrote down was that we don't violate private citizens' constitutional rights. Well, let's don't violate the United States citizens who live in Colorado, their constitutional rights.
There is an amendment at the desk. Will the clerk please read L006?
Amendment L006, amendment printed bill page 4.
Senator Rich.
Thank you, Mr. Chair. I move Senate Bill L006 to Senate Bill 005.
That is a proper motion to the amendment.
Thank you, Mr. Chair. This amendment, L006, it restricts the scope of Senate Bill 005 to sworn federal law enforcement officers and excludes state officials, private persons, contractors, and other entities engaged in immigration enforcement activities. This bill currently applies to any person who is enforcing or contributing to immigration practices, not just federal agencies. This amendment aims to protect state and local law enforcement, as well as residents of Colorado who are actual citizens of Colorado, who may be involved with immigration practices. This amendment addresses the redundant nature of the bill and limits the scope of its provisions to federal agencies. You see, I carry around the Constitution as well, and I believe that this is a reasonable amendment, and I ask for an aye vote on L006.
Senator Weissman.
Thanks, Mr. Chair. Members, I need to ask for a no vote on this amendment, and the reason is actually the Constitution that we both carry a copy of. There's a doctrine called intergovernmental immunity that arises out of the Supremacy Clause that says that a state may not enact a law that sort of differentially aims at the federal government. As amended by this amendment, that's exactly what 5 would do. So we can't have that. I need to ask for a no vote. We do write it in terms of any person acting under color of law. It's important to note that change we made in the Judiciary Committee report. A truly private person who is acting as a private citizen can't violate somebody's constitutional rights, because a violation of constitutional rights arises when somebody is acting under color of law. Constitutional rights protect the people from government. They don't protect the people from other people. Other civil and criminal law protect private people from other private people who might do them wrong, but that's not what we're talking about here. To the point about state law enforcement officials, there was a bill, the senator from Brighton referred to it, SB 2217. It had bipartisan support, actually. If somebody is wronged in whatever context by a state peace officer, they're going to bring a claim under that law, not this one, bluntly, because that is better for them. Because qualified immunity is disavowed under SB 217. CRS 1321-131 if you want to look it up. Qualified immunity applies here, and we made more, we stated that more clearly in the committee, in the Judiciary Committee amendment. So I think state law enforcement are very clear through post-training and otherwise what their parameters are. Frankly, state law enforcement agencies that I talk to, I think, are pretty horrified by what's going on out there. We've talked about what's in Colorado, what's in other states. All right, here's what's happening in Colorado. Windows are getting smashed in cars in Alamosa, and glass is raining down on children. I know the minority leader knows about that. 5'2" middle-aged women are being thrown to the ground and pinned down by federal officials in Durango. Agents with generic uniforms that say sheriff or police are walking around Northwest Aurora, my district. And then I call up the city manager, who is the direct report from the police chief. Is this you? Nope. I call up my sheriff. Is this you? Nope. Colorado law enforcement identify themselves, absent very narrow exceptions. So we have an appropriate legal framework for state peace officers. It is legally important, notwithstanding that we craft this bill to speak in terms of any person who violates your rights. I don't favor an amendment that would bring this bill into a degree of constitutional jeopardy. For that reason, I oppose this amendment.
Senator Carson.
Thank you, Mr. Chairman. Just to speak a little about the amendment by our colleague from Grand Junction, I think, again, this is just an effort to try and narrow the bill in a way that makes sure we don't end up with endless settlements, endless list of people that could be subject to complaints by protesters. The senator from Aurora has indicated certain episodes which have occurred. I don't know all the facts, but certainly the way he has described them, I would not approve of them. But let's make sure we're focusing on the actual wrongdoing that we would want to protect against here, valid, legitimate violations of someone's constitutional rights. Otherwise, we're just going to have people in the whole chain of command subject potentially to complaints and lawsuits and litigation and settlements. So I think the senator, again, like the previous amendment, is bringing something that improves the bill and just narrows it more clearly to where we want to focus on potential abuses. So I support the amendment.
Further discussion on the amendment? Seeing none, the motion before us is the adoption of Amendment L006. All those in favor say aye. Aye. Those opposed, no. No! The noes have it, and that amendment is lost. Senator Kirkmeyer.
Thank you, Mr. Chair. Members, heard that there's a question as to why we aren't championing this bill, because it's to protect from federal overreach. No, the way I read the bill is it's to be able to allow one individual to sue another individual. I mean, right here in the summary of the legislation, the bill allows individuals who have had their constitutional rights violated, which would have to be proven, during a civil immigration enforcement action to sue an individual participating in the enforcement event, whether or not they're acting under the color of law. This bill doesn't say that it's only whether they're acting under the color of law. It says whether or not they are. Oh, there was a committee amendment. Thank you. No wonder that changed in the fiscal note. Thank you. All right, well, that's good to know. All right, so a person who is injured during a civil immigration enforcement by another person who, whether or not they're acting under the color of law, right? Is that what it says? Struck whether or not, by another person who is acting under the color of law. So that could be a law enforcement official. That could be a firefighter. That could be a Division of Wildlife individual who may be acting under the color of law. That could be pretty much any first responder. But that's what this bill is about. It's about allowing individuals to sue another individual. That's what this whole bill is about. and the part about the maximum extent permissible under the United States Constitution. A grant of immunity, and there's a whole list of immunities here, does not apply in an action brought pursuant to this section. This happened before in a different law. It happened back in 2019, Senate Bill 217. Governmental immunity, Colorado governmental immunity, has changed. And so what happened, at least at local government, is that it got really very difficult to hire law enforcement officials. It got extremely difficult to hire individuals in our correctional facilities at the county level. We already know we have individuals, it's very extreme, we have a workforce shortage, it's hard to hire people in the state's correctional facilities. So a law enforcement officer, and this is what they said to us as a Board of County Commissioners, if our immunity's gone, why should we walk out the door and protect anybody every day when we could lose our house for just merely doing our job? That's the concern that's brought up. We all know where this bill's going. It's headed to court. First case, it'll go to court. And the other thing I want to point out to you is in the next section on page 5, or in this, 4, section 4, or paragraph 4, and as used in this section, unless the context otherwise requires, civil immigration enforcement means an action to investigate, question, detain, transfer, or arrest a person for the purpose of enforcing federal civil immigration law, does not include an action committed by a peace officer who is acting within the scope of their peace officer's duties consistent with state law. I don't know how that relates to and goes back to all the laws that have been passed that have turned us into a sanctuary state. I don't recall the number on the bill last year or what portion of statute it's in, but the law last year. That's pretty much said any individual, any state employee, any bus driver, the individual from the Department of Labor who didn't want to turn over documents that the governor thought he should turn over to the feds. We put in state law that if you do anything to work, essentially, this is how I'm paraphrasing it. I'm sure there'll be a attorney who comes down here and talks about maybe how it's different, but this is how it was interpreted, at least by everyone else, is that you can't work with the feds, or you get penalized up to $50,000. Remember the deputy in Mesa County? Got challenged? Could have cost him $50,000 a day. Wasn't it a day? There was a penalty, even if it's just $50,000, period. I don't know how much you think law enforcement officials make, but it's not that much. So, to the maximum step permissible under law, a grant of Colorado governmental immunity does not apply in an action brought pursuant to this section. What that means to your everyday worker, everyday law enforcement individual, everyday anybody, is, look, you're not going to get Colorado governmental immunity. It'll be on you. You will not be covered under the immunity. That's what that means to the folks who are on the ground who do this, to the first responders, any first responder, essentially. And as used in this section, civil immigration enforcement does not include an action committed by a peace officer who is acting within the scope of the peace officer's duties consistent with state law. Clever language. As long as they're consistent with state law. Well, remember, we have a state law that says if you work with the federal government, you can get penalized. You get a penalty. These two sections, these from line 1 through line 615, most first responders, law enforcement, people who are covered under the Governmental Immunity Act and these other intergovernmental immunities, qualified immunity, feel like their immunity will be in jeopardy. And they could lose everything. After Senate Bill 19217 passed, it was difficult to hire people. What has occurred since then, and with all of the other laws that have been passed? Law enforcement walks away. We've become the second most dangerous state in the nation. And then there's also this other obligation. First responders have an obligation and a duty under federal law. They have things that they have to comply with under federal law as well. And then I'm just going to direct you to the fiscal note. So the fiscal note says that it's $125,000, half an FTE. Those are the state fiscal impacts. That the costs are assumed to be paid from the risk management fund. The risk management fund comes from affected agencies, which is a mix of general fund, cash funds, and federal funds. So it's going to be determinant upon which agency is going to have to pay into the risk management fund to pay for the approximate $3.3 million per year beginning in 26-27 that the Department of Personnel and Administration estimates that the risk management expenditures will increase by. Now, typically, the risk management fund gets general fund, it gets cash funds, and federal funds. Usually, it's about 60%. When we're doing reappropriate funds, moving things around and doing all this and getting it from the state agencies, at least 60% is usually from the general fund. So we can count on that 3.3 million, it's probably going to be about 2 million in general fund. What's missing in the fiscal note is the cost to the locals. So first of all, the cost to locals is going to be, it's going to be more difficult for them to hire anyone to provide for the safety in our neighborhoods, to provide for the safety in our county jails. It's going to be more difficult for them. But there's nothing in here about how much it costs or how much these pending lawsuits will cost local governments. Nothing. There's nothing in here, and under the color of law, I mean, we have a lot of first responders who have duties and responsibilities under the law. That one, we're jeopardized, first of all, because we're a sanctuary state and because of the law passed last year. And then because we keep putting things into law about Colorado Governmental Immunity Act, making it more difficult for us to get any first responder. Any first responder.
There is an amendment at the desk. The clerk, please read L007.
Amendment L007, amend printed bill, page 5
Senator
after line.
Kirkmeyer.
Thank you, Mr. Chair. I move L007.
To the amendment.
Thank you, Mr. Chair. This amendment only applies during times when a statewide disaster emergency is declared by the governor, or an emergency or a major disaster in the state is declared by the President of the United States. So a presidential declaration in our state is declared. And what it says is, notwithstanding any provision of this section, which is on page 5, after line 18, notwithstanding any provision of this section to the contrary, a person does not have standing to bring a civil action pursuant to this section for an injury as a result of a conduct that occurred during a statewide disaster emergency declared by the governor. And typically, folks, just so you know, when a statewide disaster emergency is declared by the governor, that is when the president will declare a disaster in our state. This is just in our state. Disaster in this state declared by the President of the United States. If he doesn't declare a statewide disaster or a state disaster, meaning the President of the United States, we don't get a presidential declaration, it doesn't open up any federal funds. or limited federal funds. So it would only occur during a statewide disaster emergency that not only law enforcement, but first responders will not have to hold back. So if we're in a situation where we're having an emergency disaster and a first responder, an emergency medical technician, EMS guy, firefighter, law enforcement officer, a health care first responder acting in their responsibility to respond to the disaster, if they don't know if they are detaining or questioning. They don't know who they're detaining or questioning. They're not asking them. They're not asking them, could this be a civil immigration enforcement? They're not saying that. But if somebody is looting from a store, law enforcement officer, local law enforcement officer, detains them and starts questioning them, it could be a problem. It could be a problem. So all I'm asking for is that during a disaster emergency, that notwithstanding any provision of this section, a person does not have standing to bring a civil action pursuant to this section for injury as a result of the conduct occurred during a statewide disaster. Folks, things happen in a disaster emergency. When you're trying to assist people, when you are trying to assist them, maybe to remove them from the fire area, and they resist. There are a lot of people, when you tell them to evacuate, that an emergency evacuation order is in place, they don't leave. I mean, I can think of flooding situations, fire situations, where people are like, no, you know, if my house is gonna go, I'm gonna go with it. I'm of that age, I'm not moving. People won't leave in an evacuation. So if a first responder forcefully removes someone from their home, and they don't know that there could be a civil immigration, that the law could be that, you know, they're detaining and they're detaining or questioning someone that could be involved in a civil immigration enforcement issue. Do they really have to have this situation occur? Do they really have to have where their governmental immunity, their immunity is stripped from them? I mean, we tried the knowingly and intentionally part, that didn't work. So in an emergency disaster, when it's been declared by the governor or by the president in our state, this section would not apply to those first responders. I ask for an aye vote on Amendment L007.
Senator Weissman.
Thank you, Mr. Chair. I'm going to ask for a no vote. I think even after that discussion, it's a touch unclear the full extent of a disaster declaration intended. This one famous example we talked about years ago in a committee where there had been a problem with the wheat harvest, or perhaps it was the corn harvest, and believe it or not, a disaster was declared by way of unlocking or hoping to unlock, federal funds. Obviously, COVID was quite a long disaster. So these things have a way of going on for a while under conditions that we wouldn't necessarily inherently think of. At any rate, I don't think constitutional rights take a break. I think actually the experience of our country at the founding and the conditions that gave rise to the Bill of Rights that, again, have been enforced in state courts for a long time, whose antecedents were enforced in the courts of England before we were a country. I can cite you cases from the 1760s. It's exactly under disaster or emergent conditions that sometimes, under the wrong kind of authority, civil rights and civil liberties are most likely to be trampled. It is under such conditions when we need to be most attentive to protecting constitutional rights, including by way of remedies. There was talk up here of lawsuits and lawyers. Yeah, this is a bill to let people, if their rights are violated, file a lawsuit, because that's how you enforce your rights in this country. DC v. Heller was a lawsuit. McDonald v. City of Chicago was a lawsuit. The end of Roe was a lawsuit. And if somebody shot 10 times in the back after an investigation, I think they ought to at least have the chance to file a lawsuit too. Frankly, even if there had been a disaster declared. I ask for a no vote.
Further discussion on this amendment? Senator Kirkmeyer.
Thank you, Mr. Chair. I think people generally have the ability to file civil action pretty much at any point. They've got a lot of opportunity to file civil action if they think they have been treated wrongly and treated inappropriately. People have those abilities. It's the consequences and the unintended consequences of this law that I'm concerned about. After we've passed several bills down here, well, not we, after bills have been passed down here, law enforcement, first responders, and they just move somewhere else, like out of state, because they don't feel valued. After some of the laws that have been passed, law enforcement just stands back. They don't do anything because they're afraid to act. After that Mesa County deputy, the Attorney General went after him, and he thought he could pay a fine of $50,000. It sent shockwaves through the law enforcement community. The last thing we want is for a first responder, if there's a huge fire that's occurring in Aurora, and it's taking over buildings, and it's causing a problem, or in El Paso County, because it actually happened when I'll just use El Paso County as an example. When they were having those fires a few years ago, it looked like all of Colorado Springs was burning. Last thing we want is for a law enforcement, first responder, a firefighter, an emergency technician, is to hold back because they're afraid of being sued. And they're afraid that they've already lost their governmental immunity, and they're afraid they'd lose their home and everything that they have fought for with their own family. That's what this is about. The emergency disasters don't go on forever. The governor has to set a date for those. In a presidential declaration, there are specific dates set within the declaration determining the time of the disaster and the duration of the disaster for which the federal government would pay any money out during that disaster. The same thing happens within the state. They don't go on forever. So again, it's the unintended consequences. First responders holding back in a disaster, in an emergency, not a good idea. There are unintended consequences to the legislation we pass. We all know it. But do we really want them holding back? It's already bad enough we're the second most dangerous state in the nation. We talk about protection from federal overreach. I would just like protection in my neighborhood. I'd just like to have protection in my community and my county. I'd like law enforcement, I'd like firefighters and emergency responders, any first responder, to know that I've got their back because they have our back. That's what this amendment is about. I ask for an aye vote on L007.
Further discussion on the amendment? Seeing none, a division has been requested. Division has been requested. All those in the chamber not entitled to vote, please be seated. The motion is the adoption of Amendment L007. All those in favor, please stand and remain standing without moving around the chamber until the count is complete. Please be seated. All those opposed, please stand and remain standing. The chair is not in doubt. Amendment L007 is lost. Any further discussion on the bill? Senator Baisley.
Thank you, Mr. Chairman. So the essence of Senate Bill 005 is this sentence: a person found to have violated the United States Constitution while participating in civil immigration enforcement is liable to the injured person for legal or equitable relief or any other appropriate relief. I want to bring attention to this Constitution that is referred to in this bill, the United States Constitution, specifically Article 4, Paragraph 4, which reads, "The United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion and, on application of the legislature or of the executive when the legislature cannot be convened, against domestic violence." So I want to put on record that I believe it is arguable that if an agitator is interrupting the authority and responsibility of the United States government in its action, guaranteeing us against invasion and against domestic violence, if someone injures an officer who is enacting that provision and injures that officer, then that person would be subject to the liability described in this bill. Thank you, Mr. Chairman.
Senator Frizzell.
Thank you, Mr. Chairman. In speaking about Senate Bill 5, I just kind of want to go on record about my thoughts on this bill and echo some of the sentiments you've already heard today. First of all, this bill is extremely broad in application. It is not just, and we've tried to run some amendments that I believe were very well thought out and common sense, but narrowing this to federal immigration officials makes perfect sense to me. And the reason why it makes perfect sense is that my good colleague from Brighton is correct. Local governments are the ones who are going to be bearing the financial burden for this bill. Local government. And the costs of those issues that, when they arise, are going to be passed directly onto those citizens in that locale. I also want to talk a little bit about the role of local control in this matter, because what this bill does, because of the financial burden being passed to local government, is that it really will work to prohibit local law enforcement from participating in civil immigration enforcement. It just will. I know that in the communities that I serve, that I represent, the Douglas County Sheriff's Office takes their role in immigration enforcement very seriously. And they view the federal government as a partner, not an adversary. And I appreciate that mindset. I really do. I appreciate that mindset because it's healthy. It keeps our communities safe. Now, yeah, there's going to be occasional bad actors. There are in any industry or profession. There are going to be bad actors. And we already have laws on the books that deal with that. But this mindset of painting all law enforcement as bad is detrimental to our communities. It's detrimental to this profession that, you know what, we rely on. Colorado has a crime problem. The second most dangerous state in the country? Is that the Colorado we want? Is that the Colorado that our citizens deserve? I think it's our responsibility in this chamber to support first responders, not denigrate them. Support them for the good work that they do. That is not what this bill is about. I ask you for a no vote on this bill, on Senate Bill 5. This bill is not good for our communities because it takes away local control. It is not good for the citizens that we represent because it will make this state less safe. If we don't have people who are willing to raise their hand and take an oath to protect and serve our communities, if we don't have those people, then we'll become even more lawless than we already are. Thank you.
Senator Zamora Wilson.
Thank you, Mr. Chair. So, as someone who has served in the military, I support strong national sovereignty, border security, and this bill raises concerns. As far as it will deter federal immigration enforcement, and it's going to create new civil liability in Colorado courts. Immigration laws are to uphold the rule of law and protect national security. Also to preserve the integrity of the legal immigration process, and those are enforced. And this measure is going to create a chilling effect on our enforcement. This is going to cause recruitment to go down because now they are incurring a huge risk. And as my colleagues already mentioned, the second most dangerous state, Colorado. And we're going to create a situation which is going to cause a decrease in recruitment of our law enforcement. Is that really what we want? As mentioned, if such individuals are considered protected by the Constitution, I mean, that's what we have the Constitution for. They are protected. This bill has broad language. When we look at, especially the costs, it's, my goodness. With the broad definition, we are going to see increased costs in litigation. As I mentioned, the fog of war in these contentious situations, it's guaranteed. In the I'm looking at the litigation costs. So there's going to be some unknowns, and obviously in the complexity of the cases and case outcomes. And it states that we're going to see a total cost of over $125,000 per year. We're going to see settlement costs, and they can range tens of thousands to millions of dollars. An increase in the judicial workload. And as was stated before, who's going to pay for this? The majority are local government. State and local governments will have increased costs for litigation, settlements, and risk management. And as my colleague from Brighton pointed out, 60%, when we're talking about in the risk management, $3.3 million for the years 26 through 27. 60% is going to come out of the general fund, about $2 million. Is this really what we want? Putting the burden on our local governments, decreasing our law enforcement when we're already ranked number 2. It's an overreach that threatens our effectiveness on national security. It prioritizes potential claims of non-citizens over citizens. What safeguards exist to prevent frivolous or politically motivated lawsuits? We've tried to put in some guardrails. I don't see any. And so, again, you're going to see an increase in the demand of these lawsuits. It's going to be a burden on our judicial system, our local system. It's going to be a huge cost to the taxpayers. And I will state it again, if protecting constitutional rights is the goal, then why don't we support reforms that are at the federal level, rather than creating a state-level workaround that invites preemptive challenges. I urge a no vote on SB 26005. Thank you.
Senator Rich.
Thank you, Mr. Chairman. And just to piggyback on something that was just said, you know, there's already 50 counties that have voiced their upset about the unfunded mandates. And this is clearly one of those unfunded mandates that I haven't seen anyone or any of the sponsors concerned about it this time. But this bill threatens lawful immigration enforcement practices with vague language that could impose onerous legal punishments on law enforcement and ICE agents who are lawfully performing their duties. This bill will virtually allow anyone, including non-citizens, to frivolously file suit against law enforcement agents, thus needlessly impeding immigration enforcement activities that aim to protect communities. I think I did hear one of the sponsors say, yes, there'll be lawsuits. Well, that just furthers, you know, that profession to file lawsuits. This bill poses a significant obstacle to federal immigration officials and their local law enforcement partners, undermining their ability to enforce immigration laws effectively and efficiently to ensure community safety. The bill enables individuals to obstruct immigration enforcement by encouraging lawsuits and legal challenges, often frivolous. The bill fosters an environment of retaliation against immigration personnel, escalates tension, and increases the risk of conflict and violence during immigration enforcement efforts. This bill continues to solidify what I believe Colorado has become, a pro-criminal state. I ask for a no vote.
Minority Leader Simpson.
Thank you, Mr. Chair. Colleagues, I find myself thinking about a comment from the good senator from Denver in this kind of really weird, odd policy conversation. Certainly want to advocate and stand up for protecting people's constitutional rights. That's inherent in all of us, I think. So the challenge is, like, how do we have this policy conversation with that end game in mind of truly protecting people's constitutional rights? I think about, as the bill was introduced, and recognize it was amended in committee, but as introduced, it certainly felt like, I just characterize it as adding fuel to the fire, so to speak. There's so much happening at a national level, and the good senator from Aurora also identified within my own district, there were certainly instances of immigration enforcement whose tactics didn't align with my value system. I'm not sure they rose to the level of violation of constitutional rights, but it did feel, again, that we are taking steps towards really just compounding the circumstances rather than, from my perspective, truly trying to protect constitutional rights. So, again, and I recognize that the bill was amended in Judiciary Committee, but as introduced, the bill had language, a person who is injured during civil immigration enforcement by another person who, whether or not under color of law, violates the United States Constitution while participating in civil immigration enforcement, may bring a civil action against the other person. Boy, the wheels were just spinning in my head about who those individuals are that were, whether or not under the color of law, and not as a practicing attorney with not even a simple country lawyer, I'm not actually sure what it means to be acting under the color of law. Like, I got to dig a little deeper to get an appreciation for that terminology. But again, as introduced, it certainly created an atmosphere that it felt like, man, this is my neighbor, anybody that had some connection to an enforcement officer, provided them information potentially that then violated somebody's constitutional rights, that they end up being held liable. That seems pretty challenging from my perspective. But to the sponsor's credit, they did reference and talk about amending the bill, and that language now reads in the pre-amended bill, a person who has their rights that are guaranteed by the United States Constitution violated by another person who now says acting under the color of any federal, state, or local law is participating in civil immigration enforcement may bring a civil action against the other person. A person found to have violated the United States Constitution while participating in civil immigration enforcement is liable to the person whose rights are violated for legal or equitable relief or any other appropriate relief. So I'm also struggling to think about the consequences. It's not fear-mongering. This is truly trying to understand unintended consequences of policies that we construct. But a person found to have violated the United States Constitution while participating in civil immigration enforcement. I'm not sure how far the description goes for participating in. I think about employers potentially and inquiries from immigration. And I don't know the law in that space either. I don't know what they are required potentially to divulge or not, or what privacy pieces exist for folks that are here undocumented. So I don't even know how to talk in that space, but again, it makes the wheels start turning and thinking about those unintended consequences of employers or acquaintances. It just gets really convoluted for me to try to work through what I believe are liable to be unintended consequences of the policy. We offered an amendment earlier today with some description about, it was really Amendment L005, and it added a clarifier that said relief except that the person is not liable to the person who had their rights violated if the person who had their rights violated provoked the conduct that caused the violation. So again, the wheels start spinning a little bit and engage with the sponsors to some degree, maybe new terminology for me from a legal perspective, what constitutes provoked? But it did spark an interest, and I'm not sure that that definition exists anywhere right now, but it did spark some conversation and thought for me about our constitutional rights, and we'll talk just about the First Amendment in particular. They're not 100% absolute. There's the cliche always, you can't run into a crowded theater and yell fire. You don't have that constitutional right. So in this instance, thinking about this, trying to strike the right balance. Where does my constitutional right end and where does somebody else's constitutional rights begin, and how they interact and sometimes compete and sometimes complement each other. This is a very nuanced, balanced conversation, I think worthy of discussion. I don't support the bill either as introduced or amended, but truly want to stand up and help protect people's constitutional rights. Does this set a framework and a groundwork going forward that becomes more problematic and again maybe incentivizes more and more interaction, not always well-intentioned interaction to draw people into circumstances that end up getting people in circumstances they struggle to deal with. I wished we could I think there are probably, I know there are a number of immigration policy conversations unfolding in front of us this session. I thought we had reasonable conversation early with a resolution, and again, a recognition that at times our immigration system is truly dysfunctional. And it's incumbent upon us in this chamber in particular to think about having thoughtful, engaged, professional conversations about a recognition of some of the dysfunctionality and how we might move the ball forward and create better outcomes for everyone involved. With the sponsor's permission, there's one more amendment being drafted. Would you consider just a senatorial 5? It's a very simple amendment, and we're nearly ready, I think. I would request a senatorial 5.
We will go into a senatorial 5. All right, Senator Zamora Wilson.
Thank you, Mr. Chair. So as I had mentioned about, my concern in this bill is the cost and the unknown. We see that that the state expenditures are around $125,000, but I believe there's going to be more, and so I have an amendment.
There is an amendment at the desk. Will the clerk please read L010?
Amendment L010, amend printed bill
Senator
page 5.
Zamora Wilson.
Thank you, Mr. Chair. I move L010 to Senate Bill 26005.
To the amendment.
Thank you, Mr. Chair. So, as I mentioned, there's going to be costs. We look over in the fiscal note under risk management that they're looking at expenditures will increase by about $3.3 million per year beginning in fiscal year 2026 and 27. And as my colleague from Brighton mentioned, possibility of 60% coming from the general fund. However, that's depending on the department. We could have the Department of Safety where all of it could be coming from the general fund. And so this amendment, what it does is the Department of Personnel will include the amount of money spent. They will highlight if the money spent from the risk management fund in this bill if it includes the amount spent. So if enacted, including the amount spent to defend the actions brought pursuant in this to that beginning in November 2026 and in November every year thereafter in the budget request for the upcoming state fiscal year submitted to the Joint Budget Committee pursuant to Section 23208. Basically what I'm doing is also highlighting in the SMART Acts that if there's any money, it's red flagging, it's highlighting the money that has been spent. What this is bringing about is transparency. I think it's a very reasonable ask. We need to know truly if this goes over, what the intended costs are, and it just highlights it. And there is no fiscal note. And so I ask for an aye vote on L010.
Further discussion on the amendment? Senator Kirkmeyer.
Thank you, Mr. Chair. Members, this is a pretty simple amendment, and it's for a first-time legislator who wants to ensure transparency and have an understanding of how we get information from the executive branch. There's a departmental difference in the fiscal note that instead of $125,000, Department of Personnel Administration, who manages the risk management fund, is saying that it could be more like $3.3 million or more. And all she's asking for, and there should not be a fiscal note here, because she's just saying to the Department of Personnel, in your budget request to the Joint Budget Committee, that you just need to tell us how much was spent from the risk management fund to the Joint Budget Committee. And then the next step is, and just report that at the SMART Act hearing. Now, they would have to do this. If we ask for it, we could ask them for it to bring it up, but now it's in law, or she wants it to be in law, so that it's clear every year we will have a very clear, transparent understanding of how much money is being spent out of the risk management fund, whether it's general fund money, because depending on the department, this could be all general fund money. I know in the fiscal note it says general fund, cash funds, and federal funds, but depending on which department it is, it can end up being all general fund monies. So that's all this is asking. Transparency, simple report, there should be no fiscal note, and ask for an aye vote on L010.
Senator Gonzalez.
Ask for a no vote.
Is there any further discussion? Seeing none, the motion before us is the adoption of Amendment L010. All those in favor say aye. Aye. Those opposed, no. No. The noes have it, and that amendment is lost. Seeing no further discussion, the motion before us is the adoption of Senate Bill 5 as amended. All those in favor say aye. Aye. Those opposed, no. No. The ayes have it, and Senate Bill 5 is adopted. Majority Leader Rodriguez.
Thank you, Mr. Chair. I move the Senate proceed out of order to take up Senate Bill 18.
The motion is to proceed out of order to take up Senate Bill 18. All those in favor say aye. Aye. Those opposed, no. The ayes have it, and that motion passes. Will the clerk please read the title of the Senate Bill 18?
Senate Bill 18 by Senator Wallace and Colker and Representative Froelich and Garcia, concerning legal protections for the dignity of a minor and in connection therewith suppressing a court record associated with changing a minor's name and requiring the court to consider as a relevant factor when determining parenting time and allocation of decision-making responsibility whether the minor's parent recognizes the child's identity as it relates to a protected class.
Senator Wallace.
Thank you, Mr. Chair. I move Senate Bill 2618 and the Judiciary Committee report.
To the Judiciary Committee report.
All right, in the Judiciary Committee, we had several amendments. They ensured that youth name change record suppressions in Section 1 is clearly just prospective, so we're not talking about any previous name changes. We also allowed access to these documents upon presentation of an affidavit, and to remove the requirement that minors have to publish their change of names, which would undo the purpose of the bill. And then finally, we struck all of Section 2, which would have included children's protected classes and best interest considerations for family court. That is no longer in the bill.
Thank you. Further discussion on the committee report. Seeing none, the question is the adoption of the Judiciary Committee report. All those in favor, please say aye. Aye. Any opposed, say no. All right, the ayes have it. The committee report is adopted. Senator Wallace.
Thank you, Mr. Chair. Despite all of that work, we have just one technical amendment.
There is an amendment coming to the desk. Mr. Schaffler, please read L6 to SB 18.
Amendment L6, amend the Judiciary Committee report
Senator
dated.
Wallace.
Thank you. I move Amendment L006.
To the amendment, to L6.
This amendment is a technical update for statute reference.
All right. Is there any further discussion on L6 to SB 18? Seeing none, the question is the adoption of L6. All those in favor, please say aye. Aye. Any opposed, say no. The ayes have it. L6 has passed. Back to the bill. Senator Wallace.
Thank you, Mr. Chair. In its amended form, this bill will suppress legal name changes for minors, which are currently public record. Suppressed records can only be accessed by the applicable party, the courts, and law enforcement. This provision will not apply to records and will not be, and minors' name changes will not be suppressed if they are under adjudication. And as with any other legal proceeding, minors' parents still need minors still need their parents' permission in order to change their names, and will not be able to do so without their parents' awareness. In fact, name changes like these are filed in the name of the minor's adult parents. Further, minors change their names for many reasons. These include religious and cultural naming ceremonies, family changes like adoption, and gender transition. This legislation brings documents for these name changes in line with other similar government documents. Currently, these court records are public, which means minors who have legal name changes can be identified through record searches and AI data scraping, and the public accessibility of these documents puts youth at risk. So this bill is about protecting minors who change their names in an array of circumstances, and I ask for an aye vote.
Thank you. Senator Colker.
Thank you, Mr. Chair. Just to add on to that, in other parts of our court system, we have, for example, dependency and neglect cases, juvenile adjudications, foster youth in transition, and any criminal case where a child is a victim or a witness. All those are suppressed. The child's name is suppressed. So we're adding this in name changes where it's being done in other places, and I ask and I vote.
Is there further discussion on Senate Bill 18? Senator Kirkmeyer.
Senators. Senator. Earlier on the floor, did see.
Looks like there's an amendment
Whatever. Sure.
coming up to the desk.
Did you
Senator
call me?
Kirkmeyer.
Thank you, Mr. Chair. Thank you, Mr. Chair, and appreciate the comments made by the good senators from Boulder and Centennial, Boulder County and Centennial. Where is she from? Longmont, sorry. Good senator from Longmont and from Centennial. I do have an amendment at the desk, and we can just get right to it.
Okay, Mr. Schaffler, please read L7 to SB 18.
Amendment L7, amend the Judiciary Committee.
Senator Kirkmeyer,
Thank you, Mr. Chair. I move L007.
to the amendment.
Thank you, Mr. Chair. Appreciate again all of the amendments that were made in the Judiciary Committee. It is a big deal, given where this bill started, where again in this bill it had information with regard to allocation of parental responsibilities. This was in the original bill. Granted, it is no longer in the bill now, which included parenting time and decision-making responsibilities. All this amendment does is just confirm what the good senator from Longmont just said, that parents, not a parent, but parents would have to consent to the minor child changing their name. So it couldn't just be one parent, it would have to be both parents. And I'm just making sure. So this line would be added in the judiciary report. In the part where it says, beginning on July 1st, 2026, if a petitioner under 18 years of age at the time of filing the petition and with the consent of the petitioner's parents or legal guardians. So it would take both. So again, given where, I think we all know about House Bill 1312 from last year, given where that was, and given where we are at with the original introduction of this bill with regard to allocation of parental responsibilities and also determination of parenting time, I would just ask the sponsors to consider this, because the amendment would ensure that the court cannot suppress a child's name change petition unless both parents consent. It reinforces the principle that major decisions affecting a child's identity should not be made unilaterally or without full parental participation. By preventing suppression absent mutual consent, the amendment promotes procedural fairness. Both parents retain the right, and I think it's important that we have both parents retain the right to be informed and heard in proceedings that materially affect their child's legal identity. That is all this asking. And I heard the good senator from Longmont say that it was parents, and so I'm anticipating that was the senator's thoughts in the first place, that it was to be parents and not just one parent. And all this does is just affirm that it would, and safeguard, ensure that it is with the consent of the petitioner's parents or their legal guardians, both. So we don't end up with a parent whose parenting time, or they face adverse custody or parenting time consequences. So I would ask for an aye vote on L007. Thank you.
Members, the question is L7. Senator Wallace.
Thank you, Mr. Chair. I appreciate the good senator's efforts here. This is already in law that parents have to be consulted if as children make these choices. If parents don't have decision-making per family court, then they already still have a right to be heard on these issues before anything progresses. So if they don't have custody or decision-making of their children already, they already have a right to be heard in court for this. So this would be, undoing mechanisms that are already in place and through family court procedure.
Is there further discussion on L7? Seeing none, the question is the adoption of L7. All those in favor, please say aye. Aye. All those opposed, please say no. No. The noes have it, L7 fails. Further discussion on Senate Bill 18. Seeing none, the question is the adoption of Senate Bill 18. All those in favor, please say aye. Aye. Any opposed, say no. No. Ayes have it. Senate Bill 18 is adopted. Madam Assistant Majority Leader, or Majority Leader, Senatorial 5. All right, we're back. Mr.
Janice.
Majority Leader.
Thank you, Mr. President. I move the Senate proceed out of order to take up Senate Bill 31.
Members, the motion is to proceed to consider Senate Bill 31. All those in favor, please say aye. Any opposed, say no. The ayes have it, and we will proceed to consider Senate Bill 31. Mr. Schaffler, please read the title of Senate Bill 31.
Senate Bill 31 by Senators Lindstedt and Rich and Representatives Camacho and Soper concerning the lawful use of a prescription drug product containing a Schedule I controlled substance.
Thank you. Senator Rich.
Thank you, Mr. Chair. I move Senate Bill 31.
And there is a committee report as well, Senator.
Oh, and the Health Committee report, sorry.
Very good. To the committee report.
Thank you, Mr. Chair. In the Health Committee, we made one amendment. It was L001, and it would tweak the language to clear that any Schedule I drug approved by the FDA and DEA would be available in Colorado and will be dispensed in Colorado in the same ways as any other prescription drug.
Very good. Further discussion on the HHS committee report. Seeing none, the question is the adoption of the committee report. All those in favor, please say aye.
Aye.
Any opposed, say no. A couple of ayes have it. The committee report is adopted. To the bill, there is an amendment coming to the desk. Mr. Schaffler, please read L2 to Senate Bill 31.
Amendment L2, amend printed bill, page 3, before line
Senator
9,
Lindstedt.
insert.
Senator Lindstedt.
Thank you, Mr. Chair. I move L2.
To the amendment.
This is a clarifying amendment that makes sure that natural medicine is not included. It wasn't included in the bill, but we wanted to put some clarifying language so that folks are comfortable. Ask for an aye vote.
All right, is there further discussion on L2? Seeing none, the question is the adoption of L2 to Senate Bill 31. All those in favor, please say aye.
Aye.
Any opposed, say no. The ayes have it. L2 is adopted. To the bill, Senator Rich.
Thank you, Mr. Chair. This bill reduces red tape by removing the need for Colorado to conduct its own separate rescheduling process after the federal government has already acted. Maintaining a parallel system requires significant time and resources. And over time, this bill is also likely to save taxpayer dollars by avoiding unnecessary regulatory proceedings and potential legal disputes over conflicting federal and state classifications.
Thank you. Senator Lindstedt.
Thank you, Mr. Chair. I think what this bill will do is ensure that care is accessible and efficient. So I ask for an aye vote. It's definitely the right thing to do.
Thank you. Any further discussion? Seeing none, the question is the adoption of Senate Bill 31. All those in favor, please say aye.
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 Any opposed, say no. The ayes have it. 31 is adopted. Mr. Majority Leader.
Thank you, Mr. Chair. I move the balance of the calendar lay over until Tuesday, February 24th.
Members, the motion is to lay over the balance of the calendar until tomorrow. All those in favor, please say aye.
Aye.
Any opposed, say no. The ayes have it. The balance of the calendar will lay over. Mr. Majority Leader.
Thank you, Mr. Chair. I move the committee rise and report.
You've heard the motion to rise and report. All those in favor, please say aye. Any opposed, say no. Nonetheless, the ayes have it. We will rise and report.
Senate will come to order. Mr. Schaffler, please excuse Senator Danielson. We'll take a senatorial 5. Members, we are back in the game. Senator Weissman.
Thank you, Mr. President. The committee has been meeting and has had a couple bills under consideration. Mr. Schaffler, please read the report.
February 23rd, 2026. Mr. President, in committee of the whole begs leave to report has had under consideration the following attached bills being the second reading thereof and makes the following recommendations thereon. Senate Bill 5 as amended, Senate Bill 18 as amended, Senate Bill 31 as amended, passed on second reading and ordered engrossed and placed on the calendar for third reading and final passage. Senate Bill 53, Senate Bill 43, Senate Bill 84, Senate Bill 46, laid over until February 24th, 2026, retaining their place on the calendar. Senate Bill 37, laid over until February 25th, 2026, and retaining its place on the calendar.
Senator Weissman.
Thank you, Mr. President. I move the Senate adopt the report of the Committee of the Whole.
The motion is adoption of the Committee of the Whole report. There is an amendment at the desk. Mr. Schaffler, please read S001 and Senate Bill 18.
Amendment S001. Senator Kirkmeyer, move to
Senator
amend.
Kirkmeyer.
Thank you, Mr. President. I move S001.
To the amendment.
Thank you, Mr. President. This is an amendment to the Committee of the Whole report to show that Amendment L007 did pass. L007 to Senate Bill 2618 did pass. The amendment was pretty simple. It just said that the petition, that it would take the consent of the petitioner's parents, not just a single parent or legal guardians. I understand that parents get notified whether if they do not have custodial rights of their child, but they only get heard. They don't have consent. This could happen after custodial rights have been decided, and years later, and all of a sudden one of the parents may be cut out of making what are very important decisions in a child's life that may not have been mediated at the time of custody when maybe the child was younger. So again, the judicial forms are very clear. Both parents do get heard, but consent is not necessary by both parents. And what this amendment did was require that consent by the petitioner's parents, both parents, would be required. So I am asking for an aye vote on S001.
Further discussion. Senator Wallace.
Thank you, Mr. President. Members, I urge a no vote on this amendment. There is a family court system that is set up to handle these things. If a parent has lost custody of their children, they are still able to be heard around name changes like this, but they are not able to make the final decision. Putting this amendment in would change this from every other structure of family law and how parents' time and other things are accorded. So I would urge a no vote.
Seeing no further discussion, the motion is the adoption of S001 and Senate Bill 18. Are there any no votes? Senators, Mr. Majority Leader, Cutter, Wallace, Marchman, Gonzalez, Kip, Judah, Amabile, Henriksen, Snyder, Weissman, Ball, Colker. The Majority Leader again. Sullivan, Lindstedt, Bridges. Please add the President. With a vote of 15 ayes, 17 noes, 0 absent, 2 excused, and 1 vacant, S001 and Senate Bill 18 is lost. Again, the motion is adoption of the Committee of the Whole report. Are there any no votes? Senators, Kirkmeyer. Committee of the Whole report. Senator 05. Again, members, the motion is adoption of the Committee of the Whole report. Are there any no votes? Senators, no votes for Committee of the Whole report. Senators, Frizzell, Zamora Wilson, Kirkmeyer, Pelton B, Carson, Pelton R, Catlin, Liston, With a vote of 24 ayes, 8 noes, 0 absent, 2 excused, and 1 vacant, the committee of the whole report is adopted. I need something to read. Yeah, there it is. Senate Bill 5 is amended, 18 is amended, 31 is amended, passed second reading, order and gross place accounted for third reading and final passage. Senate Bill 53, 43, 84, 46 laid over until 2/24/2026 and retaining their place on the calendar. Senate Bill 37 laid over until 2/25/2026, retaining its place on the calendar. Consideration of governor's appointments. Consent calendar. Mr. Schaffler, please read the appointments listed on the consent calendar.
Members of the Juvenile Parole Board, effective November 16, 2025, for terms expiring November 15, 2029. Lori Comer of Denver, Colorado, to serve as a representative of the Colorado Department of Labor and Employment, appointed. Kim Branham of Thornton, Colorado, to serve as a representative of the Colorado Department of Public Safety, reappointed. Heidi Jean Hess of Clifton, Colorado, to serve as a public member of the Western Slope that is not employed by the state governor, reappointed.
Majority Leader Rodriguez.
Thank you, Mr. President. I move for the passage of all the appointments on the consideration of governor's appointment consent calendar, which are Lori Comer of Denver, Kim Branham of Thornton, and Heidi Jean Hess of Clifton for the Juvenile Parole Board.
Any discussion? Seeing none, the motion is the confirmation of the appointments on the consent calendar. Are there any no votes? With a vote of 32 ayes, 0 noes, 0 absent, 2 excused, and 1 vacant, those appointments are confirmed. Message from the House.
Mr. President, the House has passed on third reading and transmitted to the Revisor of Statutes, House Bill 1070 and House Bill 1182. The House has passed on third reading and transmitted to the Revisor of Statutes, House Bill 1071, House Bill 1034, and House Bill 1136, amended as printed in House Journal February 19, 2026, and House Bill 1115, House Bill 1096, and House Bill 1142, amended as printed in House Journal February 20, 2026. The House has passed on third reading and returns herewith Senate Bill 10. The House has passed on third reading and transmitted to the Revisor of Statutes, Senate Bill 52, amended as printed in House Journal February 20, 2026.
Message from the Revisor.
We herewith transmit without comment House Bill 1070 and 1182, without comment as amended, House Bill 1034, 1071, 1096, 1115, 1136, and 1142, without comment as amended, Senate Bill 52.
Introduction of bills.
Senate Bill 120 by Senator Marchman and Wallace and Representatives Zokai and Bradley concerning law enforcement procedures related to missing persons.
Straight to the governor's desk. Judiciary. I'm just joking. Announcements. Senator Weissman.
Thank you, Mr. President. Judiciary Committee, we are meeting in just a little bit. Usual time, 1:30, usual place, Old Supreme Court to hear 4 bills. They are 1035, 1064, Senate Bill 70, Senate Bill 71. Members, we have closing in on 100 witnesses in total for our afternoon's docket. Please don't make any evening plans. See you soon.
What? Senator Kolker.
Members, Education Committee will be hearing at 1:30 today. We are hearing one bill, Senate Bill 67, and have a number of appointments to the Institute of Cannabis Research Governing Board.
Senator Assistant Majority Leader.
Thank you, Mr. President. Senate Transportation and Energy will be meeting at 1:30 in Committee Room 352. We'll be hearing for action only Senate Bill 26021.
Senator Pelton, Radiant.
Thank you, Mr. President, but I think you need to get your eyes checked. It's
I
that
do.
time of year again.
I do.
Or time of the week again. Bible study tomorrow morning down in the basement, 7:15. Come feed your soul and we'll feed your belly too.
Very good. Mr. Majority Leader.
Thank you, Mr. President. I move the Senate adjourn until 9 a.m. Tuesday, February 24th, 2026.
You've heard the motion. All those in favor say aye.
Aye.
Opposed, no. As having Senate will adjourn until 9 a.m. on Tuesday, February 24th, 2026.